The moment I walked into the courtroom, I knew I looked exactly the way they wanted me to look. No lawyer at my side, no briefcase, no confidence. Just a man in a cheap suit that didn't quite fit anymore, standing alone while my ex wife sat with a full legal team spread out like a military formation. Leather folders, laptops, whispered strategy. They didn't even bother lowering their voices. They didn't need to. People assume silence means weakness. I've learned that lesson the hard way. I caught the smirk on her lawyer's face before I sat down. Not even subtle. The kind of smile you give when the outcome is already decided and all that's left is paperwork. My ex didn't look at me at first. She stared straight ahead, chin lifted, calm and polished. The posture of someone who believed the worst part was over. They thought I was broke. That was a story everyone in that room had already agreed on. I could feel it in the air. The frozen accounts, the emergency motions, the rushed hearing, the way my name was spoken like an afterthought. This wasn't a trial to them. It was a cleanup operation. I sat where they told me to sit, folded my hands, said nothing. The judge hadn't entered yet, but the performance had already begun. Her attorney leaned over and whispered something to her. She nodded once, controlled, efficient, like someone checking items off a list. I recognized that look. I'd worn it myself, back when I still had leverage. Across the aisle, one of her associates glanced at me, then looked away, already bored. I wasn't a threat. I wasn't even an inconvenience. I was a formality. That was the point. When the bailiff called the room to order and the judge took the bench, I kept my eyes down. Not submissive, just empty. I let my shoulders sag a little, let the silence stretch when my name was called. I answered plainly, no emotion, no edge. Every instinct in my body screamed to correct them, to explain, to fight the narrative forming around me. But I didn't, because this wasn't the beginning of the story. It was the last act. The judge flipped through the file, already annoyed. You could tell by the way he exhaled through his nose, the way his pen tapped once against the paper. Another divorce, another dispute over money that probably wasn't there anymore. Her lawyer stood first, confident, sharp. He spoke fast, clean, like he'd rehearsed this in front of a mirror. He outlined the marriage, the separation, the financial realities. He used phrases like diminished capacity and lack of liquidity, while glancing in my direction just long enough for everyone to understand who he was talking about. I didn't object. He mentioned the frozen accounts. I nodded. He mentioned the absence of counsel on my side. I said nothing. He suggested the court move quickly, spare everyone unnecessary delays. He smiled when he said it, like he was doing me a favor. The judge looked at me then, really looked, for the first time since I'd entered the room. "Mr. he said, do you understand what's being proposed here?" I did. Perfectly. I also understood what they thought I didn't understand. "Yes, Your Honor," I said. That answer seemed to satisfy him. He went back to the file, back to their version of events, back to the assumption that this was a man who had already lost everything worth fighting for. What none of them realized was that every word they spoke, every document they rushed to enter into record, every confident assertion they made without checking twice, all of it was tightening something around their own necks. I wasn't here to defend myself. I was here to let them commit to the lie. And they were doing a perfect job of it. They assumed the damage had been done long before we ever stepped into that room. And to be fair, from the outside, it looked that way. The accounts were frozen. The apartment was gone. My name had quietly disappeared from things it used to be attached to. Friends stopped calling. Business contacts stopped replying. When people believe you're broke, they don't wait for confirmation. They adjust instantly. That wasn't an accident. I'd learned something years earlier, watching other men implode in courtrooms just like this one. The moment you look desperate, the moment you rush to defend yourself, you become predictable. You start reacting instead of shaping the space around you. I didn't want to react. I wanted silence to do the work for me. So when she filed the emergency motion to freeze joint assets, I didn't contest it. When my card stopped working, I didn't make calls. When word started circulating that I was in trouble, I didn't correct anyone. I let the story travel faster than the truth ever could. People are careless when they think you can't afford to fight back. Her legal team proved that within minutes. They pushed timelines. They leaned on assumptions. They framed everything as if the numbers were already known, already verified, already final. They spoke in summaries, not specifics, confident summaries. I watched them build a version of me that was convenient, a man who had overreached, a man who'd lost leverage, a man who was now just trying to survive the fallout. Every sentence they offered relied on one core belief, that I had nothing left to protect. The judge didn't challenge them. Why would he? The file looked thin on my side. No attorney, no counter motions, no visible resistance. This wasn't shaping up to be a battle. It was shaping up to be an administrative conclusion. At one point, her lawyer turned slightly toward me, just enough to include me without addressing me directly. "We're prepared to proceed today," he said. "Given the respondent's financial position, there's no practical reason for delay." Respondent, financial position, no practical reason. I could almost hear the door closing in his mind. The judge glanced at me again. "You're choosing to represent yourself, correct?" "Yes, Your Honor." He raised an eyebrow. Not impressed, not curious, just faintly annoyed. "You understand that proceeding without counsel can significantly affect the outcome." "I understand." That seemed to settle it. He made a note, the kind of note judges make when they've already decided how this ends. What none of them noticed was that I hadn't denied a single thing they said. I hadn't argued numbers. I hadn't disputed access. I hadn't claimed hardship or injustice. I let their narrative stand untouched because every unchallenged statement they placed on the record wasn't just an assertion, it was a commitment. And commitments have weight. As the hearing moved forward, the tone shifted from formal to casual. Dangerous territory. Lawyers get sloppy when they think the finish line is close. They start speaking for speed, not precision. They summarize what should be proven. They assume alignment where there is none. I watched it happen in real time. Her lawyer referenced assets he believed no longer existed. He described structures he didn't fully understand. He spoke confidently about timelines that weren't as clean as he thought. Each time, I kept my head down, answering only when asked, never volunteering clarification. Silence invites projection. They filled it eagerly. By the time the judge leaned back in his chair, rubbing his temple, I could feel the shift approaching. Not the explosion, not yet. Just the subtle moment when something ordinary begins to feel slightly off. He flipped to a page in the file, paused, then flipped back. For the first time since the hearing began, he stopped listening to the lawyers and started reading for himself. And that's when I knew the room was about to change. Pressure doesn't arrive all at once. It tightens gradually, like a room losing oxygen while everyone pretends nothing has changed. Once the judge started reading instead of listening, the rhythm of the hearing broke. The questions slowed. The interruptions stopped. Her lawyer noticed it too. I could see it in the way he straightened his papers, suddenly more careful, more precise. That's when they turned their attention fully to me. Not aggressively, not yet. First came the polite kind of pressure, the kind meant to make you talk. The judge asked about my income. I answered with numbers that were technically correct and emotionally useless. He asked about access to funds. I explained freeze without commentary. He asked why I hadn't retained counsel. I said I didn't believe it was necessary. That earned a look, a long one. Her lawyer jumped in before the silence could stretch too far, clarifying on my behalf, framing my answers in ways that benefited his argument. I didn't correct him. I let him speak for me. That alone seemed to confuse him. Most people interrupt when they're being misrepresented. I didn't. The judge let him finish, then turned back to me. "Is that accurate?" he asked. "Yes." Another pause. He wrote something down. I had no idea what. I didn't need to. What mattered was what wasn't happening. No emotional appeal, no desperation, no anger. Just compliance. Calm. Measured. Too measured. I felt my ex shift in her seat for the first time. Not much, just enough to betray discomfort. She'd expected me to crack under questioning, to over-explain, to slip. Instead, I was giving them nothing to push against. That unsettles people. Her lawyer tried a different angle. He emphasized timelines again, pushing the idea that delaying resolution would only increase costs I couldn't afford. He spoke about finality and closure, words designed to rush decisions. The judge nodded, but his eyes stayed on the file. Then he asked something small, so small it almost felt accidental. Mr. he said, tapping the page, this account here, the one referenced in the financial disclosures, when was it established? Her lawyer answered immediately. During the marriage, Your Honor. The judge raised a hand, stopping him mid-sentence. His gaze never left me. I asked him. That was new. I gave the date, precise, unemotional. The judge frowned slightly. Not suspicion, calculation. He flipped another page. And this structure, who initiated it? Again, her lawyer moved to speak. Again, he was stopped. I did, I said. The room grew quiet in a way that had nothing to do with decorum. The judge leaned back, eyes narrowing just enough to signal interest. He wasn't looking for a gotcha. He was looking for clarity. And clarity has a way of unraveling stories built on assumptions. Her lawyer cleared his throat. Your Honor, with respect, the respondent's involvement doesn't change the material reality. The judge held up a finger. Let me finish. He looked at me again. This time, not as a problem to be processed, but as a variable he hadn't accounted for. I just want to understand something, he said slowly. You've been very cooperative. You're not disputing the freeze. You're not requesting continuances. You're not challenging the proposed framework. I nodded. Yet you seem remarkably unconcerned with the consequences. There it was, the thing they'd all been circling without naming. I met his eyes for the first time. I am, I said, just not about the things you think. That earned a few raised eyebrows. Not shock, curiosity, the dangerous kind. The judge glanced once more at the file, then set his pen down. He took a breath and asked the question that changed everything. The question itself didn't sound dangerous. It wasn't dramatic. It wasn't accusatory. That's why it worked. The judge leaned forward slightly, resting his forearms on the bench, and looked at me the way someone looks at a puzzle piece that doesn't quite fit. Mr. he said, before we proceed any further, I need to ask you something. Her lawyer shifted, already preparing to intervene. My ex straightened, expecting a formality. The judge didn't look at either of them. When the joint accounts were frozen, he asked, were you left without access to funds or without access to those funds? The room went still. It took half a second for the distinction to register, long enough for her lawyer to miss it, long enough for my ex to relax instead of tense. I didn't answer right away, not to be dramatic, to be precise. Without access to those funds, I said. The judge's pen paused midair. Her lawyer frowned, just slightly. He glanced down at his notes, then back up, like he was checking whether he'd misheard. The judge nodded slowly, as if confirming something to himself. So the freeze didn't leave you insolvent. It limited access to a specific set of accounts. That's correct. The silence this time felt different, heavier, the kind that presses on the ears. Her lawyer stepped in fast. Your Honor, with respect, the respondent's financial disclosures indicate. I'm aware of what they indicate, the judge said calmly. I'm clarifying what they don't. He turned another page. These disclosures list assets directly controlled during the marriage, he said. They do not necessarily reflect the totality of financial reality. That word, totality, landed hard. My ex looked at her lawyer now. Not panic, confusion. The judge looked back at me. Why didn't you contest the freeze? He asked. I answered honestly, because it achieved what it was meant to achieve. He raised an eyebrow, which was to demonstrate reliance. That finally did it. Her lawyer's pen slipped from his fingers and hit the table with a sharp click. He recovered quickly, but the sound lingered longer than it should have. The judge didn't acknowledge it. Reliance on what? He asked. On the assumption that restricted access equals financial absence. The judge sat back. He wasn't frowning. He wasn't smiling. He was thinking. I see, he said quietly. For the first time since the hearing began, he turned his attention fully to the other side. Counsel, he said, your argument rests heavily on the premise that the respondent's financial disclosures. Yes, Your Honor, her lawyer said too quickly. And you're comfortable with that premise? The judge asked. Her lawyer hesitated, a fraction of a second too long. We are relying on the disclosures provided. The judge nodded once. Then I'll need to verify something before we continue. He turned back to me. Mr. he said, do you have any financial interests, structures, or holdings that are not reflected in these disclosures but are nevertheless lawful and relevant to this proceeding? My ex's breath caught audibly. I didn't look at her lawyer. I didn't look at her lawyer. I only looked at the judge. Yes, I said. The word echoed louder than it should have. And, the judge continued, were those interests established before or during the marriage? Before. That was the moment the room tipped. Not collapsed, not exploded. Tilted. Because everything they'd built depended on the idea that I had nowhere to stand. And now the ground under them was starting to move. Once a statement like that is on the record, there's no such thing as going back to business as usual. The judge didn't react immediately. He didn't need to. The shift had already happened. The courtroom wasn't theirs anymore. It was his. And he was now asking questions that didn't belong to anyone's script. He folded his hands together and looked at me steadily. Are these interests active? He asked. Yes. Accessible? Yes. Her lawyer leaned forward. Your Honor, if I may? You may wait, the judge said, without looking at him. He turned back to me. And these structures, were they disclosed during discovery? They were not requested, I replied. That answer mattered, not legally yet, but procedurally. It forced the pause in the logic everyone had been following. The judge nodded slowly. So the assumption made by the court and by counsel was an assumption. Yes. He exhaled through his nose, not in frustration, but in recalibration. Judges don't like surprises, but they like being misled even less. Her lawyer finally spoke again, voice tighter now. Your Honor, with respect, the respondent is introducing ambiguity at a late stage. If there are assets, we would request immediate disclosure and… The judge raised a hand. No, he said. What you're requesting is a correction to a narrative you were comfortable advancing until 5 minutes ago. Silence. My ex's composure cracked just slightly. Her jaw tightened. Her fingers pressed into the edge of the table. For the first time, she looked at me directly. I didn't meet her gaze. The judge flipped the file closed and set it aside. Mr. he said, I want to be very clear. I am not asking you to argue your case. I am asking you to answer narrowly. I nodded. Do these interests affect your ability to comply with any potential financial ruling from this court? Yes. Do they exceed the scope of what has been represented here today by opposing counsel? Yes. That was enough. The judge turned sharply to her lawyer. Counsel, he said, you have characterized this respondent as financially incapacitated, unable to meaningfully contest this proceeding. Her lawyer swallowed. Based on the information available, you presented it as fact, not as inference. He leaned forward now, voice still calm but colder. If it is later established that the court was encouraged to rely on an incomplete or strategically framed disclosure, that becomes a very different issue. My ex opened her mouth, then closed it again. The judge looked at her. Mrs., he said, were you aware of any financial structures established by your former husband prior to the marriage? She hesitated. Her lawyer touched her arm. Too late. I knew there were some investments, she said carefully, but I was told they were no longer relevant. Told by whom? The judge asked. She glanced sideways. That glance said everything. The judge made a note, a real one this time. I am not prepared to proceed on the basis of assumptions, nor am I inclined to reward strategic omission. He looked back at me once more. Mr., he said, One final question for now. The room leaned in without realizing it. Did you intentionally allow the court to believe you were insolvent? I didn't answer right away. Not because I didn't know the answer, but because the truth, spoken plainly, would change everything. Yes, I said. That answer didn't cause an outburst. It caused something worse. Control. The judge didn't raise his voice. He didn't reprimand me. He simply leaned back and studied me the way surgeons study an x-ray before deciding where to cut. Explain, he said. I didn't rush. Rushing would have sounded like justification. I allowed the assumption to stand, I said, because it was never challenged, and because it was useful to the other side. Her lawyer objected immediately. Your Honor. The judge didn't even look at him. Useful how? He asked me. It accelerated the process, I said. It encouraged overconfidence, and it led to representations being made on record that would not have been made otherwise. That finally triggered a reaction. Her lawyer stood up, not confident anymore, defensive. This is turning into gamesmanship. The respondent is admitting to misleading the court. The judge's head snapped toward him. No, he said sharply. He's admitting he didn't correct you. Silence. That distinction mattered more than anything else said that day. The judge turned back to me. Mr. he said, I will be ordering full supplemental disclosure, not because you're required to provide it today, but because the court now needs to understand what was ignored. I nodded. And, he added, I will also be reviewing the conduct that led us here. Her lawyer finally sat down, slowly, carefully, like someone lowering themselves on unstable ground. I remained still, because this was the moment I'd been waiting for. Not the victory, the reversal. The moment when everyone in that room realized the process they tried to weaponize had turned around and was now facing them. And it wasn't done asking questions yet. Once the judge said the word review, the energy in the room shifted from confidence to containment. This was no longer about who would win the divorce. It was about exposure. Her lawyer tried to recover by doing what lawyers always do when the ground starts to crumble. He narrowed the scope. He spoke carefully now, choosing words that left room to retreat later. He reframed urgency as efficiency. He reframed assumptions as misunderstandings. The judge wasn't buying any of it. He asked for dates, for filings, for the exact language used in prior motions. Each question peeled back another layer of intent, not malice, intent. And intent is far more dangerous in a courtroom. I was barely speaking anymore. That was the irony of it. The more this unraveled, the less I had to say. Every answer from me was short, factual, boring. It forced the spotlight onto the other side, where every explanation sounded just a little too rehearsed. At one point, the judge held up a document her team had submitted earlier. This, he said, frames the respondent as financially incapacitated. Her lawyer nodded. Based on the available data. The judge tapped the page once. There is no qualifier here, no to the best of our knowledge, no pending verification. He looked up. You didn't leave yourselves an exit. My ex finally spoke. That wasn't my intention, she said quickly. I relied on my counsel. The judge acknowledged her with a slight nod, then turned back to the attorney. That may be, but reliance doesn't erase responsibility. I watched her shoulders sink a fraction of an inch. Not defeat, realization. The judge addressed the room. This court does not punish people for being quiet, he said. It does not punish people for strategic restraint. What it does not tolerate is being steered. He paused, then added, especially not by urgency manufactured for advantage. Her lawyer tried one last time. Your Honor, if the respondent was acting in good faith, why not clarify earlier? The judge answered before I could. Because he wasn't obligated to save you from your own assumptions. That landed like a verdict in miniature. The judge gathered the file, stacking the pages neatly. I am issuing a formal order for supplemental disclosure, he said. I am also referring the matter of representations made to this court for internal review. Internal review. Not sanctions, not yet. Something worse. Time. As the bailiff called the session to a close, I finally stood, slowly, calmly, the way I'd entered. My ex looked at me again. This time there was no anger in her eyes, no triumph. Just the quiet horror of someone realizing the game ended several moves ago. She opened her mouth, like she wanted to say something. I didn't wait to hear it, because the final part of this wasn't going to happen in that room. It was going to happen when the paperwork caught up with the truth. The decision didn't come with drama. No gavel slam, no speech. Just a calm, methodical reading of orders that changed everything, while sounding almost boring. That's how real consequences arrive. Quietly, in language that leaves no room to argue. The judge denied the expedited resolution. He suspended every temporary advantage that had been granted under the assumption of my financial incapacity. He ordered a full forensic review of assets on both sides, with timelines extending well before the marriage. And he made it very clear that any further misrepresentation, intentional or not, would carry consequences beyond this case. He didn't look at me when he said that. He looked at them. My ex's lawyer nodded through it, but his face had gone pale. He was already calculating damage control, already realizing how much he'd put on the record that now couldn't be walked back. The confidence was gone, replaced by the awareness that every future filing would be read with suspicion. My ex didn't cry. She didn't argue. She just sat there, staring straight ahead, finally understanding that the version of me she'd relied on no longer existed in the room. When the hearing ended, people stood. Papers shuffled. Chairs scraped the floor. Life resumed its ordinary rhythm. I didn't linger. In the hallway outside, her lawyer brushed past me without a word. He wouldn't meet my eyes. Professionals hate nothing more than realizing they underestimated the wrong variable. My ex stopped a few steps behind me. "I didn't know," she said. I believed her. It didn't matter, because this was never about what she knew. It was about what she assumed. I walked out of the courthouse alone, the same way I'd walked in. Same suit, same posture, same quiet. But the story everyone believed when I entered was dead. They thought I was broke after the divorce, thought the pressure had worked, thought I'd run out of options. All it took was one question from a judge to expose how wrong they were. And the truth is, I didn't win anything that day. I just made sure they lost the moment they decided I was finished.